strikes me that that was it Mayor Daley in Chicago just bulldozed it. Right? So it strikes me that the way to take that city added parcel out of commission for as an airport is to bulldoze it and then see what the FAA does. But
by the way, you're exactly correct, and yeah. I've said that before. And what's so funny is that the city could do exactly that.
But it is the flip of what you just said, if you end up with a judge, because what would concern me, of course, is that you can't do that without putting out some notice so planes don't go landing there thinking there's a runway. And so there's some safety issues, and so you can't sneak in the middle of the night, and so you have to make it known publicly you're going to do that. So then now you have my suspicion, maybe I'm wrong, but the FAA hears this, and maybe they go to a judge, and now you have the flip side of the thing. It's not saying you must build something, but it's saying the flip of what you said, that you must not do this right now because we want to take it to court and talk about it for 20 years.
You draw up a very good point. And the answer to that point, the difference between, hey, are you stopping a bulldozer, or are you compelling us to operate something compelling us to do something we don't want to do? They're both sides of the same coin, and you bring up a very smart point about that. The answer to that is two simple words: legal minimum. If the city simply does its legal minimum, which includes not using the last 2,000 feet, not maintaining it, fencing it off so that planes don't use it lest the lack of maintenance be deemed unsafe to them, stop selling aviation fuel, stop letting out buildings for people to use for airport purposes, then the federal court is faced, or the FAA is faced with a situation where they truly are trying to make you do something more. If you adopt the approach, we're going to do the legal minimum.
But my question is, the moment you adopt that approach, is the FAA capable of enjoining you from it and then forcing that all to be discussed in court before actual action occurred? Can the city be stopped from doing that? Just so a judge says, well, wait, let's keep the status quo and then we'll figure it out.
Yeah, the FAA, if they had the initiative, if they had the foresight, if they had the gall, could go to court and say, hey, force them to keep going.
Do you doubt that they would do that?
I do. I really do. Because remember, the FAA is eventually run by politicians, and hopefully the city of Santa Monica actually follows what its residents want, and actually takes a stand that is consistent with what it said 30 years ago, and should be consistent with what it should say today if it follows the residents. Then I think that the FAA might not act, especially when it's trying to fight to prolong an agreement that is clear as a bell, ends according to its terms.
I hope the FAA has your clarity.
I have a quick question to try to, again, tease out what type of recommendations we might make to the City Council with respect to the operations at the airport based on this presentation. So as I look at the non-aviation parcel, and it's not clearly delineated, and I'm trying to see it, but it appears to have been released in 1984, presumably as a part of the '84 agreement, and if I recall, and one of the things, for example, that the '84 agreement requires is a number of tie downs, and it looks like not the majority of it, but at least a significant portion of that parcel is tie downs. And one of the things we've been looking at, and that we will continue to look at, is the tie down licenses, which are month to month, and which the city policy we now have a city policy that tells us, to close the airport. And so to make recommendations to City Council consistent with its stated policy on a parcel that it now has control over, it might make sense to start looking at whether those tie downs it would be consistent to make a recommendation and implement a process by which the tie downs were eliminated from use but we still have our obligation with respect to the number of tie downs. You wouldn't happen to know by any chance if the city could meet its obligations to meet the minimum requirement of required tie downs without the use of the non-aviation parcel, would you?
Well, I think it would depend upon the size of the planes, right? In other words, if you have a certain size plane, you'd need a certain spacing of your tie downs. You already know that the city policy to consolidate matters on the north side of the airport. And you already know that the city policy to close the airport as soon as possible. So the question of tie downs, you really shouldn't be directed to me. It should be directed to a guy with an engineering background that says, how close can you put a tie down, and how small a plane does that require, and is that within the proprietary powers of the city?
But again, the tie-down requirement expires
It expires in 2015, but as we're going forward, and I mean, it seems to me that part of the land use presentation, part of this presentation, are to assist us in making recommendations to the city council, which is our mandate. And so what we're doing is we're getting context here in which we can use this information to make recommendations to the city council in how to operate the airport, which is, again, what we're here for. I mean, we're here to take public input, but the public input is really just one of the number of inputs that we use in order to formulate recommendations to the city council on how to operate the airport. And so what we're trying to do is use this information to provide context for recommendations. So again, one of those recommendations would be to align the use of the airport both now and after 2015 with the stated, with the city's policies, and to do what we can now and then with respect to, so for example, the land use portion might give us guidance as to what type of leases or COPs should be approved between now and then, so that the upheaval and turnover at that time would be mitigated, because having every lease expire and every tenant vacate on the same day would cause tremendous upheaval to the city and potentially devastating economic losses. But if those tenants were, or the leases or the COPs, as they came up for renewal and as subleases came in and went, were reviewed with an eye towards minimizing that turnover and the economic losses to the city, to allow for tenants who might be allowed to continue on a month-to-month basis based on the fact that their operations were in line or in conformity with the city's policies with respect to the use of the airport, then that would be a legitimate reason for us to make recommendations to the city going forward with respect to lease applications and COP applications, right? So that's the context that we're looking, as I understood it, that's the context we're looking for in all of these presentations. So the idea is to try to tease out what we can do based on this. So I think the north side, we have to look into whether or not the north side is fully, to what extent the north side is already leased, because you can't put tie downs on somebody else's leasehold, right?
correct.
But regardless of how you engineer them, you can't put them on somebody else's, leasehold.
And there are buildings primarily over there, so I don't think you would demolish
Right.
buildings to put down.
Well, I don't think you could at the moment.
Could you
right?
speak into the mic, please?
I don't think you could at the moment. So, we're not really looking at that. I'm just trying to, again, make notes for future conversations on recommendations we would make to the city. So that's why I was asking the questions about the non-aviation parcel and the tie downs. But again, if there were any other areas that it seemed like the city could start aligning its actual implementations
Is there
with,
a question over
yeah.
here?